So. Hey, good morning, everybody. Welcome back. Today's day X to the nth power in the United States of America versus Joe Big. I actually think it's day 68 or so. And, we're getting to the end. I mean, the end is in sight. We're now at the stage of the trial where the defendants are choosing to testify if they're going to testify. And yesterday, Zach Rell, R-E-H-L, one of the Proud Boys who is on trial, took the stand. Joe Biggs waived his right to testify. Enrique Tarrio waived his right to testify. And Ethan Nordine waived his right to testify. So real cross-examination or direct examination will end this morning. The government will lean in for cross. If they finish today, then the spotlight will turn to Dominic Pizzola. And Pizzola, I believe, is going to testify. And so that, you figure a day for each defendant. We're off Thursday and Friday for court-related reasons. And we'll resume again on Monday. And when I say we're off, the jury's off Thursday and Friday. We'll of course go into court tomorrow and do what we do for hours every day, argue about how many angels can dance on the head of a pin, and then get all upset with one another as a result of our inability to disagree about or to agree about anything, and our ability to disagree about everything. But the good news is the trial will soon end, and not a day too soon. I'm tired. I'm ready. I'm ready for something new. You may have seen a funny story yesterday in Law 360. I got a reach out from a reporter. We had routinely moved for a second continuance to file our appellate brief in Alex Jones's case. That is the case in which he was the target of a $1.4 billion defamation verdict. Under rules of court, there's a due date assigned to brief. If you can't make that due date, you have to file a motion for an extension of time. And there are certain formalities that need to be reached. One is you reach out to your adversary. Do they oppose? So I initially sought a 30-day extension when the brief was due a few weeks back, because I'm on trial and have been forever. So I'm still on trial and the brief is due next week. So I reach out to my adversaries and they oppose. After 4 days of internal debate, they oppose a motion for extension of time. And I'm like, seriously? I thought you privately told me you routinely grant two, but then I realized, whoa, it's the Sandy Hook families and we can't do enough for them. So then they file a written motion in opposition to my motion for 30 more days. And the appellate court takes one look at their motion and grants mine. And so the question from Law 360 is, it seems kind of obvious you were on trial elsewhere. Do you have any comment? And I didn't say what I wanted to say, which is the Sandy Hook family's sense of entitlement knows no bounds. I just said this is such a bitter case that everything gets litigated. And, that seems to be the story of my life in the last year. My cases have become extremely contentious, and it's not always all my fault, although some close to me may think it is. Hey, let's turn to another contentious topic. And Alvin Bragg, through the offices of Gibson Dunn, a mega firm in the United States, has sued Jim Jordan of the House Judiciary Committee, trying to block a subpoena for Mark Pomerantz. Mark Pomerantz is the author of the book we talked about earlier this week. And I
have to admit, Norm, I got so much joy reading this complaint, more than I typically get, just because of how prescient we appear to be at this point. Anybody watching who wasn't here, what was it, Tuesday?
I think so.
Or Monday that you did your, no. Today's Wednesday. So it was Monday where you did your book review of The People versus Donald Trump. And that was Mark Pomerantz's book. And we talked about how he really kind of made himself amenable to scrutiny by putting his sort of ethical obligations and his attorney-client privilege and all of these things on Front Street by publishing this book. And what we learn, I don't want to spoil the surprise, but what we learn, at least partially by way of this complaint, is that the Manhattan District Attorney's Office didn't approve the manuscript even after requesting it from him.
Yeah, and that's true. And Pomerantz makes great sport in his book of saying, I didn't reveal grand jury secrets, I didn't do this, I didn't do that. And he talks about all the information he withheld. Jordan and Company, in his weaponization committee, believes that the Manhattan District Attorney's Office prosecution of Donald Trump is politically motivated, and he may be right. And so they want to exercise, Jordan and Company wants to exercise congressional oversight. And Bragg's position is, and this is a very fascinating and nuanced discussion. You'll know more about federalism today than you did before you listened, I hope. Bragg's position is, well, wait a minute. I am an elected prosecutor in a locality. I am the Manhattan District Attorney's Office, and I am constitutionally obligated under the Constitution of the state of New York to exercise my discretion as the principal law enforcement officer or prosecutor rather, in Manhattan. I can choose what charges to bring and how and when, and that's within my right. And that is an exercise of a local power under our constitutional scheme of things. In other words, it's a classic example of the police power. So Bragg's suit says basically, look, Congress, you are the elected and representative body of the people nationally, but you inhabit a different branch, as it were, a different type of government. You are the federal government, and there is no general police power in the federal government, and therefore, although you sit as elected representatives of the people and have a constitutional role in terms of your oversight role over the operations of the federal government, your power does not extend to local police powers. And the genius of federalism is to create this tension between state and local powers and this division between state and local powers so that no one body can acquire too much power. And the genius of our documents, our founding documents, and our structure of government is that by fracturing power, presumably people are left a better opportunity.
Well, Norm, we're burying the lead here, right? So now, so just to bring it back a little bit, because I do want to get into what I believe is basically a 50-page complaint full of BS and gaslighting from the Manhattan District Attorney's Office here, artfully written, and I give them credit for that. However, the big picture here is that the House Judiciary Committee under Chairman Jim Jordan, which we've talked about Jim Jordan before. I think I've expressed some of my skepticism with respect to his efficacy or portended efficacy as the Republicans now have control of Congress. He appears to be pretty aggressive here. And what the House Judiciary Committee is attempting to do is subpoena Mark Pomerantz for testimony related to this. Right.
Okay. Yeah. Fair enough. But I'm not sure I buried the lead yet, because I think the complaint buried the lead. And by the way,
absolutely, I agree. Yeah. So we agree. Go ahead. Sorry.
Fat Alvin and Company didn't draft this. They relied on Gibson Dunn, and I think that's a huge tell. A firm with national reach, who have lawyers appearing on behalf of the DA's office, undoubtedly pro bono, as part of their desire to see that it's never Donald again. But look, here's the constitutional issue in this case, and here's what I predict. The case was filed in the Southern District of New York. I can't tell from the pleading, because there are no initials there, what judge gets it. But I think the judge is going to split the baby. I think the judge is going to not grant Alvin Bragg all the relief he wants, for the simple reason that the Manhattan District Attorney's Office receives federal funding to do its job of local law enforcement. And because of its receipt of those federal funds, Jordan and Company will have legitimate oversight role over how those funds get used. And so if Jordan can tailor his investigation into how and whether federal funds were used to finance the investigation of Trump, he may get somewhere. Where I think the suit's going to fail on Jordan's, or succeed rather, on Bragg's behalf, and where I think Jordan and company have some problems is I don't think he's going to be able to get all the internal documents that he wants from Pomerantz or anybody in the Manhattan DA's office, because I do think those belong to the Manhattan District Attorney's office, and it's a federal overreach to get them. As to Pomerantz himself, there's a certain poetic justice to his getting this subpoena. You wrote the book, you went on the book tour, you criticized Fat Alvin for not prosecuting Trump. Now he's decided to do so, and maybe Congress will want to know a little bit about what your role was in that investigation. Jordan, I think, will be compelled to testify, if for no other reason that he's written a book about the process.
Jordan or Pomerantz, right?
Excuse me. Yeah, Pomerantz will be required to testify, if for no other reason that he's written a book about his observations. And I think it'll be a sort of painful examination of him in front of the committee, because there may be privilege issues that warrant his not testifying. But here's an interesting issue. We talked a lot about congressional oversight committees, I think, with respect to the J6 committee. I've had a little bit of experience with them from representing Alex Jones and a couple other people in the January 6th investigation. And you'll recall maybe that when Alex appeared in front of the J6 committee, he did nothing. Well, he couldn't help himself. He argued a little bit, but he did nothing other than take the fifth. And that was a federal constitutional privilege. What I learned is that congressional oversight committees have what are known as plenary power. They don't have an obligation, because of their plenary power, their absolute power within the legislative sphere, to obey or listen to rules of court. So you can't file a motion in court to quash a congressional subpoena. You have to file a lawsuit claiming that the committee overstepped its lawful authority, and that's what Alvin and company did here. But as to Pomerantz, when he testifies, he's not going to be able to I don't think he's going to be able to take easily to claim some sort of deliberative process or semi-executive privilege that would flow from his work in the Manhattan DA's office, unless he can drape those as of constitutional vintage. And a Fifth Amendment privilege is obviously the constitutional privilege. It comes out of the Bill of Rights. Executive privilege it flows from the separation of powers doctrine within the federal government. Will the congressional committee, or will Bragg and company, be able to constitutionalize whatever privileges they think they have for the internal operations of their workings of their office? And to me, that's the money question here. That's where the real action is in this case. So keep an eye on the committee's response to this complaint. I think there'll be some motion practice early on, intending to identify whatever privileges a member of Bragg's office may have. I think the suit will ultimately fail in its complete objective. That is, it won't stop Jordan's oversight or investigation of what's going on in Bragg's office, because Bragg receives federal funds. Now, if Bragg has some moxie, if Bragg is half the guy he thinks he is, maybe he'll say, "We don't want your stinking federal funds," But I think he's already received them, and so I think Jordan's and company's nose is under.
Yeah, in my read on this complaint was that the federal funds argument, even though that's what Jim Jordan has gone to the press with, because I do believe that is the most obvious justification of some sort of federal legislative body intervening, or at least meddling within what is otherwise a state law issue, right, within the state of New York. I think that there are additional issues to be unpacked there. One thing that I thought was really funny about this complaint that Bragg's office, by way of independent counsel, filed, is that there's no mention of the federal prosecutors declining to bring a suit against Trump on the same facts, and the Federal Elections Commission also declining to pursue anything as well. And what we don't know, Norm, from the indictment is how these otherwise misdemeanor state charges are elevated to felonies. Because what is likely is that there is some sort of election law that underlies that. And if that's the case, this does become sort of a federal issue de facto, but that's sort of shrouded. There's also, with respect to Bragg, I think that he has some real issues here, because they talk a lot about how this is unprecedented action by the legislature. And my immediate response is, of course it is. A former president is being prosecuted.
A former president and current presidential candidate.
Correct. Yeah. And they do a lot to try and minimize that, and also to do some smoke and mirrors around anti-Semitism and racism. Right.
Oh, well, yeah. Did you notice?
Riddled with sideshows and distractions about how burdened the office has been with death threats and
by the way, Alvin says, I'm the first African American elected to this office. I mean, what complaint in a federal lawsuit would be complete these days without a little bit of race pandering, as though somehow this is going to entitle him to special consideration.
It's unbelievable. I think that this is probably the best they could do, but there's no, in my mind, if there is a federal judge that looks at this, and if it's me, I'm saying 50 pages for, I guess a TRO.
Yeah, no, it's a political document. Gibson Dung, obviously, the research is sound. They recite the right cases I recognize when we were looking to challenge the J6 reach, the J6 committee's reach over Jones. But it's a failure. It's a success as a political document. It'll energize the base, and it tells Alvin's story. But I think as a matter of federal law, the court will say this is this is within the scope of the congressional power. And if, in fact, there is a remedy for Pomerantz when he seeks to testify, he's going to have to evoke it at the hearing. And then the proper way of resolving this is for Pomerantz to be called to testify, evoke a privilege, and the House conclude that the privilege is inapplicable. And if it's inapplicable, then it can seek to move to hold him in contempt, and then he can fight it there. So if I'm a federal judge, I probably look at this and say, very interesting. The underside of privilege, or underside of federalism. But I probably dismiss the complaint in a written decision that says, while there are maybe valid claims of privilege as to Mr. Pomerantz's testimony, this is the wrong forum at the wrong time. If Pomerantz has to come, he has to testify, he has to evoke the privilege. The committee has to decide whether to honor it or not. And if there's an error there, and the committee believes that Pomerantz should be held in contempt, it can do a referral, and off we go. And then the courts will obtain jurisdiction. So nice try, Alvin. Good work, Jim.
High Society is in the chat. He says TRO.
Temporary restraining order. In other
Correct.
words, an order from a court saying that a party is about to behave in a way that is so patently unlawful and will result in immediate harm to a person, to someone else, that person is entitled to an order temporarily restraining or prohibiting the party from acting until the rights of the party can be further adjudicated. It's extraordinary relief, and it's not going to happen here. Well, at least it shouldn't.
That's right. And they're asking for a TRO, a preliminary injunction, and a permanent injunction. So just to fully answer High Society's question here, the DA's office in Manhattan has petitioned a federal court, and they are asking that court for what's known as equitable relief. In other words, they are asking the court to compel, or in this case, to preclude a requirement of certain behavior. And here they're asking the court to tell Congress that it is blocking Congress's attempt to compel via subpoena Mark Pomerantz. And Norm, I think you probably caught this, anybody else that they attempt to subpoena pursuant to this underlying investigation.
Yeah, I did see the anybody else. I think Pomerantz is the easy case. I mean, he put himself out there with publication of the book. It'd be more interesting if they did Bragg.
Well, I think that he's next, right? And they talk a lot about that. I think that this complaint does a lot to sort of bring that up. I was actually surprised because they spent so much time talking about Bragg and the scrutiny that he's been under, but then there is no existing subpoena for Bragg at this moment.
Not yet, but give him a day or two. Hey, speaking of congressional oversight, I think the Weaponization Committee struck a pretty vital nerve yesterday by raising questions about whether the FBI is surveilling or infiltrating or monitoring Catholic groups as potential extremists. There was a suggestion some time ago that in an internal FBI document, Catholics who practice and favor the Latin Mass were going to be regarded as extremists and potential, domestic threats. Wow. I mean, if this had happened in the 60s and 70s, back in the days of Quintil the church committee's head would have exploded. I think that Jordan's getting warm. I think he needs to take a look, obviously, at what the FBI is doing with respect to Catholics. I think he also needs to take a close look at what's going on in the J6 cases. Information has arisen in our trial and has been reported about largely in the right-wing press about the full scope of law enforcement surveillance of domestic groups. And we had an extraordinary ruling from Judge Kelly yesterday that said, well, the Justice Department isn't responsible for everybody. They know what the FBI is up to, but you can't really tell me, he said to a colleague of mine, what the Department of Homeland Security or whatever this agency's name is called. You don't even have the necessarily correct name. You can't tell me who they are. So how can I issue an order to determine what they're doing? And so here's the challenge for Jim Jordan and company. After 9/11 and the creation of better coordination between our intelligence agencies, and how many intelligence agencies do we have in the United States, federal intelligence agencies or adjuncts of agencies conducting domestic security in the name, or surveillance in the name of security, and how many of them are embedded or are watching domestic groups? What coordination is there between these groups, and what safeguards are there to assure that the people's right freely to associate, to petition for redress of grievances, and speak out about matters of public affairs? What assurances do we have that the FBI is not trammeling upon those? And right now, I think there are more questions than answers, and we're looking to Jim Jordan and his committee to get those questions. That is a prime example of where congressional oversight can actually serve a vital national interest. I find it actually chilling to think that the FBI has opened files on conservative Catholics. I know that there have been a lot of files opened up on Proud Boys and other related groups. One gets the impression that federal investigative sources look to the Southern Poverty Law Center as the targeting entity. Tell us who we should be investigating, and then they put resources into those investigations, and we don't have the means of finding out about it, because when you try to engage the federal government in litigation, you end up fighting this hydra-headed beast, where the head of one agency says, well, this is what I think we're doing, but I can't tell you who else is doing what. Well, who does? The United States government, Thomas Jefferson once famously said, when the people fear the government, there is tyranny. When government fears the people, there is liberty. Congressional oversight is what puts the fear of the people into government. You don't have the resources as an individual litigant. Neither does Alvin Bragg. Neither does any individual in the United States. It's Congress that speaks on behalf of the people. And I think there is a national scandal ongoing right now with the infiltration and surveillance of domestic political groups that are denominated terrorists by groups like the Southern Poverty Law Center or others. And I think it's a rightward-facing investigation in ways that parallel the leftward-facing investigations of the 60s and 70s. Those investigations led to the church committee reports and reform of what law enforcement can do to people with differing political views in the United States. The pendulum has swung. It's time to have an equal and equivalent effort on facing the right now.
For sure. Just to add on to that, I wholly agree with you, Norm. And I look at two things. Number one, I look at the impact of COVID, and I've spoken about this before. You and I have connected on this issue in particular, where you have these independent governors of states that sort of fell in lockstep with one another to enact widespread closures of businesses, to dissuade organization of people. And so you have this new behavioral pattern that is very widespread, where people have been sort of, I guess, keyed to avoid congregating in that way, unless of course you fit a certain intersectional mold. Combined with that, I also look at the scope, the vast scope of the January 6th prosecutions, right? Not just the Proud Boys or what you're doing with Joe Biggs, but the literal thousands of defendants that have been prosecuted in connection with the events of January 6, 2021. I think those two things combined do a lot to dissuade people and disincentivize and chill the ability to organize and protest within the confines of the First Amendment.
Yeah,
Right?
I think that's a scary set of issues.
And then when you layer atop what you're talking about, I think that we can look at school board meetings and the scrutiny that was applied to parents, right? And the DOJ sort of nodding that they were going to consider parents that showed up at school board meetings articulating and communicating issues that they have with curriculum and the administration of the public education system, domestic terrorists, alongside of what you're saying right now. I just think that there is warranted, I think, a much bigger probe, and I'm hopeful that we won't have to wait very long for there to be teeth to that.
Well, if you see something, say something. Call your local congressman, ask them to contact Jim Jordan's office, talk about domestic surveillance of political groups, because if it's somebody you opposed yesterday, it could be you tomorrow, and it's important that government be kept within certain limits. Hey, speaking of government and the choices it makes, what's going on with Daniel Perry down there in Texas?
So the Wall Street Journal is reporting now that Daniel Perry's lawyers are looking to, I guess, get a new trial for him. Daniel Perry, for those of you who are not familiar, and I wouldn't blame you for being unfamiliar with this issue, because this is something that the likes of Cernovich and others have criticized the mainstream press for actively avoiding. Daniel Perry is an Austin, Texas man. He is a veteran, and he shot and killed someone in July of 2020. He was driving for Uber at the time. A protester in and among the riots and protests of 2020 approached his car, pointed an AK-47 at him, and he discharged his firearm, killing him. The DA there brought charges, and a jury convicted him of murder. This has sparked outrage in various circles around the United States, and what we thought was unlikely has become real, and that is that Governor Abbott, the Texas governor, has already announced that he was going to pardon Perry for this conviction.
Well, yes and no. I mean, Perry doesn't have independent pardon power in Texas. He can't. It's not like a president. He can't take a look at a roster of those convicted within his jurisdiction and say, "I'll take one from this column, one from that." Pardon. He works through a board of pardons and parole, and that board has to make a recommendation. So the prosecutor in Austin has doubling down. He's asking that board for an opportunity to present evidence to it before it makes any recommendations as to Perry. I think there's a moral to the story in Perry. Texas has a stand your ground law, and many people who support Perry believe that he was justified in shooting the protester. The protester was walking the street with an assault weapon. His purpose there was to protect his colleagues and their ability to express themselves. Perry took the position that he had a right to operate on the roads, and that when the man approached him with a weapon drawn and in such a way as to suggest it was imminently likely to be used, Perry had a right to shoot to kill. And initially, prosecutors didn't want to prosecute. The local prosecutor put his foot down. They got it done. Whether the grand jury was misled with information, whether the state presented an honest case, all of these things will be tested in further litigation. But here's the scary part. Perry was also active on social media. Yep. And as the Summer of Love became an urban, mostly peaceful barbecue in one city after another, Perry said something to the effect of, maybe it's time to get out on the streets. I'm going to have to go out and shoot a couple protesters or kill a couple protesters, or words to that effect. Those words.
I might go to Dallas to shoot looters is one of the quotes.
Okay. And those words in isolation are protected speech, because under the Brandenburg test, mere abstract calls for violence at some future date are not prohibited. So Perry's discussion of going to Dallas to shoot looters was a sentiment, frankly, many of us shared. I mean, I remember sitting at home watching all of that thinking, man, this is crazy. They're going to burn down my city, and I'm supposed to sit here and watch and be happy about it. So Perry's words were taken and applied in this context. They were applied in this trial to demonstrate his motive and his intent. So the prosecutor was able to claim Perry may have had a right to be present on the road. He may have had a right to defend himself. But if he was the initial aggressor, if he picked the fight, if he went looking for trouble, he doesn't get to avail himself of self-defense as a defense when this was the very trouble or harm he was looking for.
Well,
Now,
yeah,
here,
so, Norm,
let me just finish this one point because it's interesting. There is a movement to prevent rappers from their anti-police speech in an artistic context from being used against them in trials for fear that it would result in an unfair trial. Do we need a similar rule with respect to social media utterances? And the Perry case raises that question. I'm sorry, I cut you off, Mike.
Well, I was going to ask because this came up. So I remember I was waiting tables during law school during the Trayvon Martin case. And there was much ado in that case about Florida's stand your ground law and just the general notion of self-defense. And from what I recall in law school, and I'm not a criminal litigator, so I want to ask you this question. There is a two-step analysis within, even if you are the initial aggressor. My understanding and recollection from law school is that one's status as the initial aggressor can be purged, and therefore you could be removed as the initial aggressor for self-defense purposes if the responding party elevates their level of aggression or intent to cause harm. And I can't say with any certainty that if both parties had a firearm that that's necessarily relevant, but certainly the act of having a firearm in a state where concealed carry is lawful, or in a city where Perry was not breaking any laws by having a firearm, certainly they could say maybe he went looking for trouble. But at the point that an AK is pointed at your face, I don't know that there's even necessarily an argument that he went looking for that kind of trouble.
I think that's right. And, I don't know Texas law. I don't know how it was presented to the jury. But I think that, as a common sense application of the law, that certainly makes sense. It's one thing, to walk up to a guy at a 7-Eleven, say, your mother wears army boots. And then he says, oh, yeah. And he pulls out a gun. What are you supposed to do? Okay, shoot me. I guess I never should have said that. I hear what you're saying. Most states struggle with the standard for evaluating conduct, and they apply what's called both a subjective and then an objective standard in a two-step analysis. So first, subjectively, did Perry honestly believe himself that his life was in danger? That's his subjective analysis. If he did, his use of force might have been justified. Second, was his use of force objectively reasonable? In other words, would an ordinary person looking at him at the circumstances, believe it was right for him to do so? And so in order to win a self-defense claim, you have to prove both that you are subjectively justified and objectively justified, and the jury comes in to make those evaluations. So keep an eye on the Perry case. I don't know how quickly the Board of Pardons and Parole will act, and it's an open question in my mind whether Perry can grant a pardon if it's not recommended by that board. That would be an interesting question in and of itself.
One last thing here. T-Girl is in the chat this morning, and she says, another Soros prosecutor. So I wanted to say this because it made me remember from the complaint. They made sure to say that Alvin Bragg has never even communicated with George Soros in this complaint, which I think is going to make him amenable to scrutiny because it's common knowledge that George Soros' son is the de facto operator of his finances and deployment of those finances in elections. So I think that that's going to be really interesting. T-Girl, thank you for making that comment. It just reminded me that when I was reading the complaint, I thought that was interesting that they went out of their way to say that.
Yeah, well, it is interesting. Soros has become controversial for his backing of quote unquote liberal or quote unquote progressive prosecutors. And so, it's possible that Bragg never did speak to George, but that he took George's money through a third party or someone else, or maybe his son. We'll find out. Stay tuned for this and other exciting developments in the law, coast to coast.
Do you want to do an AMA on Friday? I asked the question in chat and I only got one thumb up and then I got one question. So I don't know that people are even excited about it. So maybe we won't do it.
Anyway. You can ask us anything and we'll answer nothing. So, yeah, well, let's do it Friday, but let's have a couple topics in our back pocket just in case, people.
Is there court scheduled for Friday, Norm?
There is not. No, we have court scheduled for Thursday, motions and whatnot. Friday's off. and then we're back at it next Monday.
Well, then perhaps we'll have a little bit longer and we can come armed with a couple of discussion points, and then we can do AMA and just go for a little longer than normal here to accommodate that. For the audio listeners, we appreciate you very much. You can find everyday stream on Apple Podcasts, Spotify, Google Play, Overcast, or wherever podcasts are found. For those of you that join the stream live, we very much appreciate you. We hope you're enjoying the new overlay, and we're going to continue to work to deliver you a better experience here. As you can see, I'm actually back on the Rodecaster and the mic this morning. Things appear to be back in working order. If you want to consider becoming a subscriber on Locals, that's really where we're aggregating our support. I think High Society was attempting to get a subscriber badge this morning. High Society, I'm going to look into that for you on the Rumble side of things. If you're over on YouTube, hey, you're in very, very sparse company over there, but we appreciate every single view and every single like. So please subscribe, turn the notification bells on Twitter, because we're live there every morning as well. And Norm, can't wait to keep talking about this stuff tomorrow morning.
Objection.
Overruled.
Right at home. See you tomorrow, folks.
See you.